Ladies and gentlemen, good afternoon. Thank you very much for joining us today. My name is Diana Baizakova. I am representing the Chamber of Commerce and Industry of Uzbekistan, the organization that supports businesses in Uzbekistan and beyond at legislative, judicial, and administrative levels, to name a few. The Chamber of Commerce and Industry of Uzbekistan is also the founder of the Tashkent International Arbitration Center, or TIAC, as we frequently refer to it, where I currently act as the director. We welcome everyone to witness what promises to be an exciting discussion on entrepreneurial risks, legal regulation, and investment dispute settlement. We relish this opportunity to host you all as our distinguished guests in our beautiful country, and we hope that you are enjoying your time here. In the interest of brevity, I would like to very briefly introduce our stellar panelists today. To my immediate left, we have Mr. Jamshid Durunov, who is the Deputy Commissioner at the Office of the Business Ombudsman of Uzbekistan, whose primary mandate is the participation in the design and implementation of the state policy in the fields of entrepreneurship, and providing legal support to businesses. Thank you very much, Mr. Aruna, for your contribution to this important field, and welcome. We're delighted to have Ms. Kristen Young, partner at White & Case law firm, whose invaluable insights and successful experience in representing Uzbekistan in investment disputes will definitely help us identify the state of affairs when it comes to investment laws and framework for dispute settlement. Next to Ms. Young, we have Ms. Dalia Khalifa, Senior Manager at IFC, whose primary expertise is in finance, investment, and private sector development. We are indeed fortunate to have Ms. Khalifa with us to give us a bird's eye view on the subject from the perspective of the financial institutions. Next to Ms. Khalifa, we have Mr. Rustam Turkmenov, Senior Counsel at the European Bank for Reconstruction and Development. Rustam has extensive experience in the region and has been involved in the majority of EBRD's debt and equity projects in Uzbekistan. And last but not least, I'm thrilled to introduce Mr. Sherzod Yunusov, partner at the international law firm Kinsteller. In Mr. Yunusov's practice, he focuses on energy and infrastructure sectors as well as the project finance. Welcome. So the overarching red thread of today's discussion is enabling environment risk mitigation, as well as effective dispute settlement. And interestingly, the issue of dispute resolution is oftentimes put on the back burner, and dispute resolution clauses are referred to by many as midnight clauses because of the fact that they're normally negotiated at the very end of the negotiation process, and little attention is given to effective dispute avoidance and dispute resolution mechanisms. And there's this old adage that says that the chain is as strong as its weakest link. So what's the weakest link in the regulatory environment for businesses and investors in Uzbekistan? What does the future hold for us in terms of investor protection and business regulation? What are the best practices which we can borrow and cross-fertilize? And in answering these questions, I would like to first give the floor to Deputy Commissioner at the Office of Business Ombudsman, Mr. Arunov. What systemic and intractable challenges do you encounter in the exercise of your function?
Спасибо. Мое выступление будет на русском.
Thank you very much. I will speak in Russian. Dear participants of the forum, first of all, I would like to thank all of you for inviting me and giving me this opportunity to have the speech in this forum, because this forum, and we know more than maybe 1,000 entrepreneurs and also investors are present in this forum. It's a very important forum for Uzbekistan. And I would like talk about my position, institute position. We had a strategy of Uzbekistan in 2016, and in 2017 it was fully approved and formed. Then we had also the law. It was the representative of Uzbekistan for protection of all entrepreneurs. Of course, as you know, it's quite a long name, but therefore we usually try to use a short abbreviation for it. During this time, of course, we increase our number of employees, because at the beginning we had only 8. Now we have 84, and we also present at every region of Uzbekistan. It helps us to assist our entrepreneurs and also give them opportunity to have a fast response and to have a latest updates of the state. And before, as you know, and now we try to participate in the policy, developing the policy of entrepreneurs. We try to make a research this sphere of economy and entrepreneurship. We meet our new businessmen and also talk to them. And of course, then we inform our authorities about the current state of affairs in Uzbekistan, in order to provide the safe environment for them. Now we have 12 different laws that we try to follow, and we also participate in all kind of hearings, court hearings, because sometimes our entrepreneurs will ask us to present them at the court level, but in the legislation, usually, if we ourselves do not participate, we are not able to really present the interest. This situation is changed, and now we are able also to take part in any kind of hearings, court hearings, and protect the rights of our entrepreneur. And of course, we have additional function. It's monitoring and coordination. And we conduct the coordination of control institutions, how they will track and how they will conduct their monitoring of our entrepreneurs. All these documentations that will be done during this monitoring period will help us to monitor each audit and also legibility of this audit. And in addition to that, recently, we had additional rights to see that our employees have right not only make a protocol of administrative violations in terms of some positions that done on different levels, but also apply different fines based on 9 articles. Also, in accordance with this law and regulation, we can coordinate with the business of all norm laws and regulations that directly involve this business. More than 500 expertise were conducted by us, and more than 1,000 different suggestions were given. So, dear participants, I can talk a lot about our business. We have practice, even though we exist only 5 years. And last year we had quite a big forum, and we talk more in detail about our activities, and it was admitted that the president created such environment for us that we have an opportunity to protect our entrepreneurs. And we try our best to help our entrepreneurs. And of course, when we say our entrepreneurs, we are talking about not only the ones, local ones, but the ones that actually conduct the activities on the territory of Uzbekistan. At the end, I would like to say that this forum will be a good platform for discussion, because here we have different types of entrepreneurs from different countries, and of course it will increase the and attract some investment projects. And I wish to all of you fruitful discussions and work. Thank you for your attention.
Rarunov. Next, I would like to give the floor to Ms. Kristen Young. We all know that the government of Uzbekistan is actively pursuing the policy of attracting foreign direct investments. We know that over 50 bilateral investment treaties were signed by the government. So, Kristen, based on your knowledge and knowledge of investment laws and dispute settlement, what should the government pay special attention to when working on and concluding a BIT with other countries?
There we go. Thank you. Thank you very much, Diana. And I want to start by really congratulating the government of the Republic of Uzbekistan and all of the forum organizers for such a successful first International Investment Forum. It is really my pleasure and honor to be here and to present today to you. And in thinking about investment protection, we all heard from the president yesterday that investment protection and investment promotion are cornerstones of the new Uzbekistan program and plan for the next 5 years. And in attracting investment to Uzbekistan, what do investors look at? What do they consider? And of course, part of what they consider is what sort of protections exist under the law and under the treaties for the investments that they will make. If there are issues, if there is, for example, an expropriation, what sort of protections exist? And so that determination is done by looking at both the law, so the law of the host state, which here is Uzbekistan, and also the treaties that have been concluded by the host state. And as Diana mentioned, the Republic has concluded a large number of investment treaties, I think about 54. 45 of those treaties are in force today. In addition to bilateral investment treaties, the Republic has concluded multilateral treaties as well that give access to dispute settlement, such as the Energy Charter Treaty. But in looking at all of those treaties, it's important for investors to evaluate both the protections that are afforded under those treaties. And so the treaties that Uzbekistan has concluded give many protections to investors that are standard in treaties across the world, such as fair and equitable treatment protection, things like national treatment protection, and also protection against unlawful expropriation of an investment. Investors should also consider that in making their investments, they want to be making that investment in a way that will have protection. And I think Uzbekistan, like many countries, when they do enter into these treaties, are ensuring protection for investments that are entered into lawfully, that are implemented lawfully. So it's important to consider that when you're making your investment, you want to make sure that you're abiding by the law of the host state so that you have protection for your investment if an issue does arise. And that's something, of course, that Uzbekistan takes into consideration when concluding bilateral investment treaties. And in addition to this protection that investors have under the multilateral and bilateral investment treaties, there's also a foreign investment law in Uzbekistan. The most recent investment law was concluded in 2020 that also provides additional protections for investors. Again, investors, even under the law of Uzbekistan, has a reciprocal obligation to comply with Uzbek law. So that's something that needs to be respected in order to benefit from all of those protections. But that is an important part of the protections available to investors. Uzbekistan continues to negotiate and enter into new bilateral investment treaties, and it's an important element to attracting the right type of investment for the country. And I think we've seen that. The interest here is really phenomenal, and Uzbekistan's done a great job to really promote and protect incoming foreign direct investment.
Thank you very much, Kristen, for your insights. Next, I would like to give the floor to Ms. Khalifa. Ms. Khalifa, we know that you're very passionate about private sector solutions and enabling environment that increases investments and grows economies. So how can the regulatory environment either enable or constrain entrepreneurships and SMEs growth? And as we look outward, what can the government of Uzbekistan do in the coming years to continue creating and enabling business environment for businesses and entrepreneurs?
Thank you, and thank you for inviting me to speak to everyone here, and it's an honor and a pleasure to be here. It's my first and surely not my last time to Uzbekistan, and I must say it's very clear, not just interacting with everyone, but just hearing what everyone's saying, that the energy is all for what is required to attract investments, retain investments, grow businesses. I mean, that's what the conference here is about. And the answer to your question, and yes, I am passionate about it, but the answer to your question is, if I could just replay the opening speech of His Excellency the President yesterday. He laid out a very ambitious plan for Uzbekistan, building on the past 5 years of a lot of reforms. And since then, I've heard many government officials speak and expound and elaborate further on these visions. And all of that is important to attract and retain investments. The topic today, we're talking about a very important element, investor protection and investment dispute settlements. And these are really important elements, often, as you're rightly said, overlooked when agreements are made. But even beyond that, even beyond getting to the point of an agreement, when an investor looks at a potential investment opportunity, a foreign investment, or even a domestic investor, there is risk. And risk is not just legal risk after you've signed a deal and you've started operating. The risk is in just even thinking about beginning to engage in economic opportunity. As an entrepreneur, the idea of risk entails a lot, and it boils down to transparency and predictability. And transparency and predictability for any investor means that the regulatory environment needs to be enabling, inviting, protective, and supportive of the entrepreneur and the firm. When a young entrepreneur looks at an investment opportunity, what are they looking at? Or when they seize a potential opportunity, what are they looking at? They're looking to see, is there access to finance? Are there access to markets? Can they find the skills? Do they possess the skills? Can they help? Does the environment help them turn their ideas into a reality? And the government here plays a very important role, not as a producer of goods and services, but an enabler for the production of goods and services. And just listening to all that I've heard over the past couple of days, it's clear that that switch is now happening in Uzbekistan. And I would like to reframe the concept of risk and say de-risking. De-risking an investment opportunity requires clearing of regulatory roadblocks, reducing discretionary decision-making, leveling the playing field, and, as I said before, transparency and predictability. Now, the good news is that the government here has undertaken many reforms over the past few years. For example, and I'm not elaborating all of them, but for example, liberalization of exchange rates, lifting of foreign exchange requirements and easing of restrictions on foreign exchange restrictions on entrepreneurs, more price liberalization, increased trade liberalization, increased recognition of the connectivity of air, rail, and road, and opening up more sectors to private investments. You can name the sectors from cotton to energy to fertilizer. We're beginning to see more and more space for private investors being made. And when you have these kind of signals being given to potential investors, that is probably the biggest de-risking that you can undertake for an entrepreneur or a firm. There still remains a lot more that needs to be done and looked at, and all we have to do again is listen to the next 5-year plan that has been referenced to know that there's a lot more that's in the works. But I would like to just focus on a few things that recent World Bank Group analysis has shown may produce an even more hospitable environment for investments and entrepreneurs. For example, we know that the entry of new firms, even with these reforms, we know that the pace of entry of new firms in Uzbekistan is not as high as comparator countries. So there is more space there for growth. The post-entry of firms, the growth path has been a little bit more sluggish. Increasing employment, although it's been increased a lot in the private sector in Uzbekistan, there's still a lot more growth potential for it to reach that of comparators countries. So what are some of the other elements that need to be put in place? Perhaps a new investment law that undertakes to build in such investor protections as are being discussed here for dispute settlements is one very important way. I think digitization and an increased role of digitization is also going to be very critical to enable firms to grow. And then another important area is the reduction in regulatory compliance costs. The number of required licenses, permits, etc., entail a large compliance burden on firms, which if you're a small firm or a small entrepreneur can be very inhibiting for you to want to engage in the formal economy. And the more entrepreneurs you bring into the formal economy, the greater is their capacity to grow, but also is the greater their capacity to return to the economy in the form of taxation, in the form of increased employment opportunities, etc. So it becomes a win-win situation to reduce compliance costs, to encourage formalization in the economy. And then, of course, we need to be thinking about closing the skills gap. How can we make our entrepreneurs in Uzbekistan, reach out, innovate, grow in their access to markets and in their capacity to dream what is possible with all of the opportunities are there. You know, we're in a post-COVID world. Supply chains have broken down. In that crisis is opportunity. It is opportunity for entrepreneurs and firms that have the capacity within the right enabling environment to continue to grow and move forward. And that's how I would see is really the main thrust of the path forward to de-risking investment opportunities in Uzbekistan, and fostering competition, reducing the state footprint so that entrepreneurs don't feel that they are competing with a more powerful competitor, being the state, ensuring that the tax regime is fair and doesn't inhibit firm growth, tackling practices so that the informal sector is encouraged to become more formal, and of course strengthening the core foundational skills of individuals coming into the marketplace. Uzbekistan has a powerful opportunity at hand, and it's clear that it is capturing this opportunity and intends to move forward towards all that is required to really de-risk and encourage as much investment, both international and domestic.
Thank you very much, Ms. Khalifa, for your very detailed answer. And before we move to Rustam for his insights and comments, I would like to ask an additional question, if I may, from Ms. Khalifa. Is there any jurisdiction or country whose experience can Uzbekistan borrow from, or cross-fertilize, or whose experience we can import in resolving those challenges that we're currently having?
So thank you for that. So I don't know that I would point to a particular country and say, that's the country you need to emulate. But what I would say is that there is a lot that can be learned from the experiences of countries everywhere, not just in Central Asia or Eastern Europe, but even further apart. The World Bank does a lot of regulatory benchmarking and looking at good practices across the world. That information is out there. I can think of good practices in investor protection that exist in countries in Latin America or in East Asia. This alternative dispute resolution is another big area where we're seeing a lot of growth in Eastern Europe, for example, where there may be good experiences there. Reducing the regulatory burden and cost compliance, lots of good experiences there from East Asia. More increasing experiences in Africa as well. So the lessons are there and the opportunities are there, but I think it's not rocket science. I do believe that where there is the right direction, which is clear that there exists here in Uzbekistan, then what needs to be done will get there. The one thing that will help you leapfrog all of this is the digitization. That is really, government to government, government to business, business to business. That is probably the one magic bullet that I would say could help alleviate and bring you to the level where you want to go.
Thank you very much. Thank you. Mr. Tukmanov, your profile features your active involvement in private equity projects in Uzbekistan. So what about investing in local businesses? What are those pitfalls and challenges that external investors face when they enter as shareholders in local businesses.
Diana, thank you very much. First of all, I wanted to greet all participants of this session and say thank you to the organizers for giving me this opportunity to speak among the distinguished members of this panel. If I may, I want to continue in Russian because I think some points that I want to say, I want to deliver to the participants here, and I think it would be better if I speak Russian to explain it in more plain sort of
Absolutely.
language. Yeah.
Thank you very much again for giving me this wonderful opportunity to present here at this forum, and this is one of the best events for the recent years in Uzbekistan, and I am a lawyer and I work for EBRD, and I work not only in Uzbekistan but with the whole region of EBRD, including different legal practices related to financing and financial equity, and we call it investment in enterprises. But actually this is a little bit different. It's better to say probably equity investment. And under the framework of my work with equity investment, I have a lot of I always work with foreign investors who would like to purchase shares of local companies, and they have a lot of questions in many countries, like in Greece and in Uzbekistan. It doesn't matter. There is a number of questions that investor indicates and learns before making his decision or before making contribution in any type of enterprise. And before speaking about this, I would like to say that I agree with the previous speaker. Ms. Khalifa was very right to say that one of the key elements is risk, and all the issues of legislation. It is also one of risks from investors' perspective, and these risks needs to be clear, stable, and understandable. And it should be the one that we can cope with. And in order to understand this legal concept, we have legislation that regulates business activities, so investors could manage their risks, including legal risks, and related to investment to private companies. And this risk is being evaluated together with a number of different other risks, financial risks, equity risks, and personnel management risks, and so on and so on. Speaking about EBRD and about my experience of investment capital, in addition to the fact that we are looking at the external legal sphere that allows businesses work in a country or allows foreign and local investors put their money. There are a lot of different risks that investors very often, who have a lot of experience, such type of risks that they evaluate, internal risks and external risks, and it is difficult to control them because you cannot change anything in a legislation system, but it's easier to control internal legal risks because they are regulated by inner corporative agreements between companies, and these internal risks are carefully evaluated by investors. And we, before making investment, we look at companies' corporate policies, corporate management, documents that regulate their policies, how they regulate disputes between the stakeholders of this company, and taking into consideration all these factors, we either suggest our solutions for change, and in 99% this is how we work and what happens, and we change corporate constitution of the company in order to make it accessible for foreign investors, not only for EBRD, who has a lot of privileges, but for many external investors, because our main task is like it was said before, actually our task to mitigate, to increase role of private sector in entrepreneurial sphere, and we are, as a bank who is aimed at development of private sector, we are trying to support our government to create conditions that are required for entrepreneurship for their development. And besides that, in conclusion, I would like to say that I would like to note the position of Mr. Urunov, and I agree with him that legislation and regulatory base and people who work there, they shouldn't make a big difference between foreign and local investors. And I'll explain why I am saying this, because very often I see that in those countries where we work, maybe it's probably a necessity in those countries where a country is trying to create a legislative system, the most prosperous system for foreign investors, because I understand that they have lack of internal capital, and that's why they have to attract foreign external capital, and they face another risk. They willing to work with foreign investors. It makes a negative impact for local investors, and this is it was very important for me to hear position of our business ombudsman, that there shouldn't be any discrimination between types of investors. All investors are important for us, and conditions for them should be equal. And of course, there are some bonus programs that allow that make foreign investors possible to have some privileges for making investment. But our main position, and our business ombudsman agrees with me, that all conditions should be equal. Thank you.
Интересно.
Thank you very much. It was quite interesting presentation, and I believe that today it would be also very interesting for our spectators to basically to see those kind of clauses or agreements that very often will be stated, and when usually it's the last ones that two sides will agree upon. And of course, how the disputes will be resolved when we talk about maybe partners and so forth. Why do you believe that such effective mechanism and tools that we have in place in terms of solving dispute in the contract among stakeholders, they can be one of the key factors of success to see basically investors in local market. Yes, of course. What I can say is that I don't believe. Of course, a lot of times this type of clauses or statement, they have some reputation, but unfortunately it's not always true, because when there is an evaluation of risks, the investor always will look at the mechanism of the dispute resolution. And of course, it's exists and it's correct that investors, before at the initial stage of investment, they don't believe that they will have a lot of disputes, but sometimes it's a misunderstanding, because starting from the second day of investment, maybe they will have some dispute. But a very effective mechanism and tool is and that will be very attractive for investors to see. I usually will tell them to investors, seasoned investors, those that do investments regularly. I usually call their attention to it because there is something usually that, for example, a chance of losing everything during the dispute. That's why the effective mechanism of solution of this dispute will allow them to continue exist together. And this mechanism and disputes can be quite different. And the level of these disputes also can be different. It can be on the level of company, on the level of already legislation, and of course on the investor himself. And of course the mechanism of disputes is very important for investors, and investors do pay attention to it, because they realize that without these effective tools of dispute resolution, any kind of policies and any kind of regulations that we will have reflected in charter, they will not be having such important weight, or will not outweigh if we don't have the way to resolve the dispute. And of course, I understand that in the beginning, they don't think about this, because of course what we call is a flower candy period in the beginning, but of course
You pay for the shareholders dispute clauses.
Да, безусловно, наверное, если говорить про
yes, of course, if we will talk about some investors, regular investors, we have to consider the specific and volume of the investments. Of course, lawyers that will work with such investors will pay certain attention to all policies and also mechanism of dispute solution. From our experience, when I say our experience, first of all, I am talking about the Tashkent Arbitrage Center. It's very interesting to note that very often we will see entrepreneurs and also foreign companies as well with a contract in which the text where it's stated, or the clause where it's stated about the resolution of the dispute has a double meaning, or maybe not clear. A lot of lawyers that are currently present here understand what I'm trying to say. It's when we mentioned the clause in the agreement, we mentioned the arbitrage institution that maybe does not exist. And therefore, we can see quite a lot, not only in Uzbekistan, but in some foreign countries as well, because I myself very actively have worked as an arbiter and also lawyer abroad, and I can say this is something we face everywhere. And therefore, when I talk about midnight clauses, I talk about contracts that are used by small or average business, medium business. Thank you.
Insights and comments. That was very useful and helpful. With Rustam's views on dispute resolution provisions, I think we've gradually come to the conclusion that a dispute resolution framework plays an important role in facilitating foreign direct investment. So I would like to therefore turn to Sherzod Yunusov, for Sherzod to shed some more light on the issue of dispute resolution in Uzbekistan and alternative dispute resolution in particular. So, Sherzod, what is your experience in the design of effective dispute resolution provisions, and what lessons have you learned in the context of that?
Thank you, Diana. First of all, I would like to express my gratitude to organizers for inviting me to speak at this session, and to participants for finding time to come to this session. If you just let me to take one step back and elaborate a bit why I do believe that dispute resolution mechanics do matter, and I think we have a consensus on this, but unfortunately, as some of the speakers mentioned, sometimes dispute resolution mechanics are underestimated, especially at the contract execution stage. And as was yesterday mentioned, President just in December of 2021 has adopted a resolution on investment program from 2022 to 2026, which envisions attracting investments of up to 70 billion US dollars. That's an ambitious but very much feasible goal, and it could be achieved if investors are attracted and are coming, and we already see that investors are coming here. And from what we see is that investors, when they do take decision on whether to invest or not in a country, what they consider, among other things, is whether the country provides an efficient court system, and whether there is an efficient pathway to enforcement of arbitral decisions. And we see that Uzbekistan has taken certain steps. First of all, adoption of a New York Convention that allows to enforce arbitral decisions. And I can tell you from my experience working at an IFI in London that, for example, a neighboring country has not ratified this convention, and we had hard time finding ways how to design a dispute resolution framework for that project. So usually this is taken for granted that the country ratified this convention, but this is a big plus. I would also mention that in 2018, the government facilitated establishment of TIAC, which is a big plus, and we recently discussed that a major oil service company is now considering to put TIAC as a forum for their arbitration in respect to contracts implemented in Uzbekistan. And the last but not least is the adoption of the law on international commercial arbitration that was ratified last year. What we see here on transaction documents is that most of the foreign finance documents are subjected to English law, and there is also international commercial arbitration that is used for resolving disputes. And again, this is due to a framework that is provided by New York Convention. As you know, many arbitration institutions, they have their recommended arbitration clauses, but there are two main reasons why parties here sometimes have to adjust those recommended arbitration clauses. And the first one is mandatory provisions of Uzbek law. On certain matters, Uzbek law requires parties to defer to jurisdiction of local courts, for example, on matters that relate to real estate. And the second is rather contractual or contextual matter, is inequality of bargaining power. It's when one party which is stronger to a contract, let's say a lender, wants additional protection and asks the other party, for example, an SME, to introduce a unilateral jurisdiction clause into their contract. What a unilateral jurisdiction clause implies is that one party, usually a stronger party, has a discretion to go either to an arbitration institution or to any other jurisdiction at its sole discretion. It could be English courts, it could be local courts. But what we see in respect to those clauses is a slight caution. First of all, I should mention there is a clash of principles that are enshrined in the civil code of Uzbekistan. On one hand, there is a freedom to contract, so parties can decide whatever they want. On the other side, and put it into the contract. On the other side, we see principle of equality of parties, and which asks that both parties should be treated equally. And we see a clash here. On the one hand, the parties agreed and put a unilateral jurisdiction clause in their contract, but for some reason one party can go to many forums and the other party can only go to one forum. And in Russia, for example, which had similar provisions, a court in the case which is called Sony Ericsson has decided that such jurisdiction clauses are void. And so many investors and their counsels, they believe that because these provisions in the Russian law are similar to the provisions in Uzbek law, there's a risk that a court in Uzbekistan can take a similar decision. So some counsels would recommend against introducing unilateral jurisdiction clause. I should say that we don't have currently published practice on unilateral jurisdiction clause, but together with TIAC, we are currently conducting a survey. It's still ongoing, but from what we see is that many of respondents, they're cautious about unilateral jurisdiction clause. And from 50 practitioners that we have asked, and those are practitioners in private practice, in-house counsels from international organizations, and employees of the judiciary system, they opine that there is a great risk of non-enforceability of such clauses or non-enforceability of the award, because the ultimate goal is to procure an award and then come and enforce it here. So there is a risk that a unilateral jurisdiction clause may somehow impact enforceability. So some other issues that we see in dispute resolution clauses is that parties sometimes take templates or precedents from other projects and maybe from other jurisdictions without thinking thoroughly how this would work in Uzbekistan. And we often see, for example, subjection of a dispute to courts of England. And this could be risky, because if a party wants to enforce this decision here, a decision of an English court in Uzbekistan, it should also consider that there is no bilateral treaty between the UK and Uzbekistan to enforce this judgment here. While if the parties deferred to international arbitration, there is a framework under New York Convention to take a decision to an award of an arbitral institution, come and enforce here. Some other issues that we see is that parties don't think thoroughly about potential consolidation. If there are many related documents, it is preferable to have the same forum, because if dispute arises, usually you want to consolidate everything and want to go to one forum. for example, one particular arbitration institution, because you don't want to be exposed to many disputes taking place in different jurisdictions. And the last mistake that we often see here is that parties forget to include a prevailing language clause. They draft the contract, for example, in Russian, and then they add an English section without providing which language of the contract prevails. And that could lead to many issues, both in respect to arbitration clause, as well as to the rest of the contract.
Thank you very much, Sherzad. Well, just for the sake of possibly non-legal individuals in the audience, I think it's important to emphasize that in 2018, there was an important milestone in facilitating the foreign direct investment that the government of Uzbekistan has taken, and that is the establishment of TIAC, the Tashkent International Arbitration Center, and later on in August 2021, the law on international commercial arbitration was also adopted, which was modeled on the UNCITRAL's law on international commercial arbitration. Why are these important? I mean, some of the benefits Sherzad mentioned, as opposed to court in arbitral proceedings, the disputing parties can choose the judge, or in strictly legal terms, an arbitrator. You can also choose the language. So as opposed to state courts, the language can be English, as an example. You can also choose in arbitration the governing law. So the governing law of the dispute, or the substantive law of the dispute, can be English law. And what's important, and again what was mentioned in Sherzad's contributions to the discussion, is the benefit of enforcing an arbitral award in more than 160 countries in the world under the 1958 New York Convention. This benefit is not available to court judgments. So even if a winning party has a judgment from the local court, it is virtually impossible for a winning party to enforce that winning judgment against a losing party, say in England or in France or in Turkey or in many other countries. And this benefits, or this advantage, is available to arbitral awards. So this is the reason why we emphasize on the importance of the development of the alternative dispute resolution. Ms. Khalif also mentioned that in her contribution. Before we conclude, there's another question that I wanted to ask Mr. Yunusov. Based on your experience working with the banking sectors, what proposals may or have the banks made to improve the investment climate in Uzbekistan?
Sure. Maybe I'll just briefly mention that before taking this role at Kinsteller, I was for 3 years working at an IFI in London, and I was involved in bankability reviews of projects, and I'm currently working on local law side, involved in legal due diligence based on which banks take decision on whether to invest in the project or not. And speaking about bankability, it's rather a loose term, and depending on whom you ask, you will get different answer. If you ask a banker would tell you something about cash flows. But if you ask a lawyer, they will speak about legal framework as well as legal due diligence in respect of project documents. And if there is a defect in the project document, lenders can often find a way and get additional protection vis-a-vis sponsors, or somehow rectifying those defects in project documents. But what is often non-rectifiable, or it's difficult to rectify, is a defect in regulations. You might appreciate that after 2016, lots of laws and regulations been adopted to accelerate the economy, and it's recognized, and we witnessed that it helped to accelerate the economy indeed. At the same time, when many laws and regulations adopted, there could be some inconsistencies, and mechanics that are provided by law on how to interpret those inconsistencies is important. So one of the suggestions that lenders may have voiced or have discussed is improving interpretation of laws. So currently, you might appreciate that laws in accordance with Uzbek law can be interpreted by constitutional court, and there are a number of entities that may address the court asking to interpret certain inconsistencies in laws. But at the same time, private individuals and legal entities who often require this interpretation, for example, in the context of investment, they lack standing, or the standing is rather limited to request such interpretation. So this could be a room for development in this regard.
Thank you very much. Kristen, would you like to add something?
No, I was just going to add one point, Diana, and that's there was some discussion about pathological dispute resolution clauses or arbitration clauses and clauses being drafted at midnight. And one thing to bear in mind is that your arbitration institutes like TIAC and also the ICC and the LCIA, there are model arbitration clauses available, and so those can be accessed online. You could pull the language out of the model clause and include it in your contract, and it will not be pathological, so it will not be declared void. So that's always something to bear in mind, and of course it can be amended by the parties, but the core model clauses are available online at each of the arbitral institutions' websites.
Yes, absolutely. I think this is very helpful for SMEs, so that they can literally just go to the website and get some help on the language for the dispute resolution clauses. Are there any further comments or feedback that the panelists would like to contribute further? Yeah, please.
I just wanted to, again, react on the panelists' remarks about the legal environment. Ms. Khalifa, I'm really sorry, but I'm still referring to you. But this is something which is, I think, is very important, but it's not something that I am sort of very experienced at. But I've been discussing this matter with other people who work in the region of legal development, creating enabling environment for the SMEs, etc., etc. The compliance costs. And I think the compliance costs are huge in the region, especially in our region. I've been speaking with one of the business ombudsmen from the neighboring countries regarding the approach that they took to the compliance costs, and they did a sort of analysis of the existing rules and regulations in respect of each sector and each sort of type of business. And the person quoted me that in order to open a barber shop in a neighboring country, I don't want to name the names, but very close to Uzbekistan, you would have to, this barber shop would be subject to 140 regulations with respect to its activity of cutting hair of other people. And the analysis actually concluded that if that barbershop were sort of complying with all these 140 regulations in full, they would went bankrupt on the day two. And one of the matters that they took, and I think this is, I mean, when Diana referred to the experience of other countries, I think it's also important to note that we do have international best practices developed by institutions like World Bank, developed by institutions like ours as well. And these international best practices, they sort of combine and create a generic framework for those regulations without, because you can't really take and import the legislation, as you know, from one country to another. You have to look at the existing laws of the country, how to adapt to them, etc., etc. But the major one, and this is the idea that I really liked, and I think Ms. Khalifa can further expand on this, and Mr. Urunov can expand on this. But this is related to the so-called risk management approach in respect of the regulatory matters. So, and I don't really want to say a lot about this because I'm not an expert, but in a nutshell, I think this is the approach which lets the businesses, well, which lets the regulator to regulate those aspects of the business which they think and everyone think are the most sort of dangerous or sort of the most hazardous for the lives, for the and for all these matters that the government, for the environment, for the social sphere, etc., etc. And this risk management approach actually says that, for example, of this barber shop, the only thing that they would need to comply is, let's say, 6 rules about bringing their scissors around and creating a proper sort of fire safety system, etc., etc. But this is and this is for Uzbekistan and for other countries in the region. This is the legacy of Soviet Union, which sort of were trying to regulate every aspect of our lives without taking into account the risk management approach. And I think this is it's a huge burden for the businesses in this country, huge burden for the business in the region, especially for the SMEs. And if that sort of issue is tackled, and this is an enormous task, but I think that would create a very enabling environment, at least for the SMEs, and to thrive. And I'm really sorry, because I need to go. I have a signing and in 15 minutes.
Sure.
So, thank you very much for everyone, and it was a pleasure again. Thank you.
We're going to wrap up, and I just wanted to briefly check, do we have any further comments or insights? And if not, please join me in giving the panel a round of applause. Thank you very much. I think from everything that we've heard today so far, Uzbekistan is on the right track, and our future can be bright and very positive if we continue implementing the reforms and changes within the regulatory and business environment. Thanks, everyone. I personally very much enjoyed this discussion, and if the audience has any questions, you can approach our distinguished panelists on a bilateral basis. Thank you very much. Thanks, everyone.